think, V, are we being taped? All right, so being taped. And I think, I'm not sure if this door locks. If it does, I will stick up a magic marker in it. Guess it might. All right, so let's just remind ourselves, guys, typical kind of scenario where let's review what we've covered to date, what we're going to cover today, and what Saturday has in store for us. So we're making super good progress here. We're exactly where we should be. And we have our general introduction, duty to the system. We have sources of authority, which you guys are becoming experts at, whether it be federal law, state law. The federal law comes in the form of the Internal Revenue Code and Circular 230. State law, you have the rules of the AICPA that govern us. And let me just chime in terms of rules and where they're found. Keep in mind that state law, judicial law, which I will argue is authoritative insofar as if you do something wrong, you have the risk of a malpractice suit, which is in Chapter 6. So we will be covering that in detail. So you have these various sources of authority. The most loose knit is malpractice at the very end. Those are state tort actions, okay? Those are state tort actions, which if everything falls into place, I'm hoping, fingers crossed, next Wednesday, we're gonna have a guest speaker, if you can. I think to me, it's a very important lecture because you're gonna get someone who spends their career trying to defend accountants from malpractice. So you wanna be very sensitive. To me, it's great to have an opportunity to have someone like that and then have a question and answer series. So again, make sure if you can to be here on Wednesday. And I don't know what time I'll be here, whether it be 5, 6, or 7 o'clock. Chapter 2, we said bifurcated into 2 parts. First part dealing with tax return preparation and dealing with the issue of what penalties taxpayers might endure if they go off the rails. And the second part deals with what penalties tax practitioners, and Viva was kind enough to say, and she's corrected, on the IRS website, they have a dedicated summary of both sets of penalties. So you can Google that and pull it off. It's not a bad thing. As V was mentioning, my exam will be open book, open note, so feel free to bring whatever resources you might think will be useful for you. So that's spelled out in Chapter 2. So you have the entirety of Chapter 2, but you also have the summaries from the IRS website. Aside from just the penalties themselves, the authors address in Chapter 2 some of the things that come up in our regular practice, dealing with what do you do with valuations and estimates, what do you do with errors and amended returns, and these are the kind of things that come up regularly in tax practice, and you guys should be aware of it. And just keep in mind, did everyone get, or I sent an email out about the paper would be due, I said a week from this Saturday, right? I forget the exact date.
Second or third.
Right.
Second or third.
And our last day of class is it 2 weeks from today?
Ninth.
6th, yeah.
Right.
Ninth.
Is it the 9th? I don't think
No,
so.
it's the
Oh,
6th.
No, it's on
Yeah,
Wednesday.
6th. Now, I did build into the calendar one extra day in case we're supposed to be for 10 sessions in case there was a snow day. So our last class will be an exam, and it will be 2 weeks from today if everything falls into place. If there's a snowstorm, just keep that other date open because we have a plan B in case we have to miss something. All right?
Which other date?
I think it's the following Saturday.
I'm not here.
we'll figure it out if there's a problem. Hopefully, so far I looked at the 10-day forecast, guys. Fingers crossed, so far, nothing on the horizon, okay? Albeit, I'm sure many of you,
The exam day is when?
right now,
Yeah.
it's 2 weeks from today.
The 6th. But
The
the rain
6th.
date is the 9th.
And then, in case there's a snow date, it would be the 9th.
The 9? Okay, I already purchased the ticket.
All right, well, we'll figure that out. If there's a problem, don't
Okay.
worry. You
Okay.
don't have to give up your ticket, okay? All right,
Thank
don't
you.
worry, we're just getting going here.
Okay.
All right, so chapter 3 deals with transactional planning and advice. And we talked about potential client conflicts and client conflicts potentially with each other. And we said that the prototype, but there's many, many others, is a husband and wife situation, right? But there is between father-son, father-daughter, mother-daughter, mother-son. The list goes on. I'm dealing today with two sisters. I mean, this sounds like a parrot, but two sisters who don't get along. And you would think there wasn't enough money. There's only $100 million they have to split between them. And somehow, if someone gets an extra $50, that's a problem. So, so we dealt with, in chapter 3, all these client conflicts, and I've said to you in chapter 6, when we have the malpractice attorney here to discuss accounting malpractice, I said, and I stand by, one of the biggest potential issues everyone in this room will have is potential client conflicts. So be careful, be careful. And then we have conflicts between lawyers and their clients. That too. Anytime you have a potential transaction with your client, you have a potential conflict. All right, so we have that. And we ended on page 150 dealing with opinion letters and written advice. So questions on the material that we covered to date. We're going to finish chapter 3. My thoughts are regarding chapter 4. We're largely going to cover issues pertaining to client confidences, and then probably on Saturday, time permitting, we will deal with issues pertaining with respect to the work product doctrine, as well as chapter 5, some of the issues contained in there. So it's a little bit of a preview of what's to come. Any questions on the material we've covered to date? Go ahead, Viva.
Okay, we had to print out the model rule also for every.
You don't have to print out all the model rules, but those that are particularly relevant you may want to have with you, all right? I will share with you, just for your entertainment value, yesterday I got to testify at the Federal District Court, and it was interesting. I will keep you posted. Supposedly they were I was the one witness called by the defense on this tax issue, and they supposedly went to closing today. And just to remind people, if and when you get called, no one here has been called ever to testify. Has anyone been a fact witness or any other kind of witness? Or so, just a word to the wise, and when you're dealing and you're being cross-examined, it is an intense mental exercise because the prosecutor will ask very simple questions, but you're on your guard because you think the trap is being played. And here is the perfect scenario, and then I'll tell you what happened, because the defense attorney, I'm doing this case pro bono because I feel really bad. I always think that people are entitled to make a mistake. Did I tell you the background of this case, guys? This guy he thought he learned that someone was embezzling money from a company, $1 million, and that the person was keeping the $1 million in a secret dresser drawer. And what would you do if you learned that someone was keeping $1 million in a secret dresser drawer? you might decide, I'll steal that money. Why? Because if you steal the money, maybe that person won't report you, right? So the psychology is, I'll steal it from that person, but they had stolen it, so they're less apt to go to the police. The problem is, he goes to the person's home, and he impersonates a police officer by doing this, so it's, okay? He gets there, goes to the dresser drawer, and he learns that the people who he thought had stolen the money had moved out 2 weeks earlier. So there's no money, he's on surveillance camera, and the police pick him up, and the rest is history. So it's kind of sad, right? I mean, it's just like a cockamamie scheme. And you know, you feel, look, no one should impersonate a police officer, no one should steal money, but people do dumb things when they're young in life, right? So having said that, my sympathies go out. He's serving time. The only question that I'm called upon, is this a state issue or a federal issue? And you might say, crimes, are they generally state or federal, guys? Generally, crimes are state issues, like theft, robbery, prostitution, drugs. Those are all state. There are federal crimes, don't get me wrong, like, you know, lying to Congress, federal crime, right? Robbing a bank can depend. In this case, it only becomes a federal crime if you steal from a business because you're interfering with interstate commerce. And interstate commerce is a federal issue. If you steal from someone personally, it's a state issue.
What
So,
about murder?
if you murder, generally state.
Oh,
It's rarely where the feds get involved. Think about it. Hold on, someone's about to come in and, all right, they saved the pen. Thank you, Mike. So anyway, my whole issue was when, and remember, he didn't really steal $1 million because there was no $1 million. But criminal law, the fact that it was impossible for him to steal doesn't mean anything. He's still obviously guilty for trying, right? Right, intent. So under state law, he will serve approximately 10 years. If it's under federal law, believe it or not, he will serve approximately 20 years. Okay, it's a lot worse. So he really wants to be under state law. So I had to go in there and argue that when he went to steal this money, that he thought the business owner had reduced this to personal assets and that it was not a business asset. So that was my role as an expert witness. And we'll see if the jury buys into my logic. But the point I was raising was the prosecutor started just peppering me with questions, and he said, well, Professor Solid, this was $3,000 to $5,000, and if it were kept at home and the person the next day brought it to the bank, wouldn't you say this was a business asset? He sort of, he turned the facts where you could imagine, right, a business owner taking money from the business, bringing it home, and then the next day paying receipts or bringing it to the bank, things along those lines. So the upshot of ultimately my testimony will be, does the jury accept the fact that the defendant who sought to steal the money really thought, no, people do bring money home from a business, correct? Everyone, you can envision someone bringing money home from a business. But they bring 3,000, maybe 5,000, maybe 10,000. But they generally don't bring $1 million home, right? Everyone agree? So this guy went through this whole exercise of impersonating a police officer and going through that whole exercise, not because he wanted 3,000 or 5,000, he wanted $1 million, as foolish as that is. So I think it's pretty compelling that it was, in his mind, he was stealing from the person's person, not from the person's business, if you see the distinction of it. And the other thing is, when someone tries to embezzle money, they're embezzling it from the business, and you guys may recall, Code Section 61, if the business owner steals money, embezzles money, do they have an obligation to report it? And they have an obligation to report it under Form 1040. And if that money truly had been stolen, they might try under Code Section 165 to secure a theft loss, right? You're allowed, subject to certain limitations for a theft loss. So I was arguing, say, this person, meaning the person who theoretically had embezzled, that embezzlement may or may not have happened, but that person, from the defendant's perspective, the person had embezzled the money and therefore was personal. So anyway, I'm just sharing with you that if you ever have to testify, you have to make sure, you guys would be very happy to know that right before I got in, I generally don't do this, but I had a large cup of cappuccino that was way too hot, but I gulped it down because I wanted to be like entirely wired for this whole thing, and I think I was pretty wired because it was going to be an intense battle. So it's an intense battle. If it were taped, I would have shared it with you, but it isn't. All right. Any other questions? That was my day yesterday.
Just off that, I'm curious, is it currently a state court or federal court?
It's a federal. I was at Federal District Court in Newark. If you guys know, right next to City Hall is Federal District Court. So it was not, there's this Essex County Courthouse, but it was not there. It was not in any county courthouse. There's only one, to my knowledge. There may be a district court in Camden. I'm not familiar with it, but there's only one district court, at least in northern New Jersey, and that's in Newark, right by City Hall. It's a very nice building. The judge, halfway through, had a coughing fit, and the court had to be adjourned as she almost passed out having a coughing fit, but it was just an aside. Okay, page 150. Opinion letters and written advice. So, I don't know, did anyone here write opinion letters, or your firms write opinion letters, written advice? Brian, any opinion letters coming out of your firm?
I think my firm probably does, but I don't.
You don't get involved in it, not yet at least.
Right.
And Andrew, any on your firm? No, you don't?
No. Or private bank.
Okay. And Ping, anything, I know you work in-house, but do you see opinion letters coming through?
No,
No?
not my side.
So no one's gonna share with me their experiences. Okay, well, let's put it this way. Sometime in your life, you'll either have to write one, or you'll see them, right? One way or another. And the question is, what do you think when you see these opinion letters? If you're writing one or seeing one, like, how should it be done? Do you have any feeling, Nick, of, like, talk to me, how should they be crafted? Is there any, given this course, given expectations here,
Gap standards?
what do you mean by that? But gap standards, why does it have any relevance here? Okay. But that's okay, but given how the authors portray this, and what obligations do you have as practitioners, or if you're reading an opinion letter, how do you calibrate the good, the bad, and ugly?
Has to be supported.
Say again.
So does it have to be supported by a substantial authority? Or?
You tell me.
And reasonable basis, is there one to?
I mean, guys, just articulate for me.
Or-
Help me out. I'm going to write an opinion letter. I come to you.
Right.
Give me some guidelines. Tell me what I should be doing.
Every position that the person who's writing the
I'm the person writing it, so give me advice. Talk to me one-on-one.
So every point that you make, you have to back it up with some kind of authority, I would say.
Why? And what kind of authority?
Substantial authority?
Always?
Yes, I would say always.
Okay, let me just ask Peter, you agree? I'm the guy gonna write a letter, you're giving me my marching orders. Talk to me about how I should.
Necessarily, I guess whatever position that we decide to take, I would want you to make sure that it's written where, it's within code and guidelines. Sometimes things could go
I don't know what you mean within code, within guidelines.
I guess it should have a substantial,
It should have gravitas, but that's a different issue. And if you say so, why not? Why can't I just write a one sentence letter? Someone says, does this tax shelter work? Can I just write, I think so.
No,
Is
because
that flawed? And if so, why?
you have
And who, I don't mean this badly, who are you to judge? So, in other words, just tell me how we should go about doing this. Because, again, you're gonna see these letters, you're gonna write these letters, you gotta know how to, you're like the Michelangelo, right? I don't mean this badly. Most people in this room, you're not gonna be working with large blocks of marble, right? But you have the equivalent, right? Your computer and paper, and you're gonna be crafting your own, David. So what are your guidelines and how to do it? And where do they come from? I mean, what do the authors suggest here? I mean, they're suggesting as you're turning pages here that when you instruct Solid how to write an opinion letter, you gotta, if I'm the client or if I'm the accountant or attorney drafting, I have to decide with the client what kind of standard has to be met. In other words, when I write the letter, is it gonna be, I'm gonna write there's a reasonable basis that the client's gonna make disclosure? Am I gonna write a letter that says there's substantial authority for the position? Or am I writing about a tax shelter? Did you get a text?
Ground floor or first floor?
Ground floor,
You said-
excuse me, first floor.
First floor, okay.
All right, thank you.
Mhm.
For those just coming in, B is gonna get Kevin. I may have trouble getting up over that. So you have to write that letter, and if it pertains to a tax shelter, right? In that instance, you have to write a more likely than not opinion. Because otherwise, the client may be in jeopardy of not having reasonable cause if it's challenged, right? If you write a letter and it doesn't meet, if it's a tax shelter and the letter doesn't meet the more likely than not standard, chances are the client can't rely upon Code Section 6664 for relief. Right? The authors also talk about a should and will standard, but to my knowledge, I've never crafted a letter like that. Although, sometimes I'll take liberties. If someone, for example, holds a capital asset for more than 1 year, for example, I'll say, hey, under Code Section 1222, that's a long-term capital gain. It will qualify for long-term capital gain treatment, right? So I won't be bashful. I won't say it's more likely than not, right? I would imagine many of you have crafted your own responses to clients, and periodically you'll sprinkle with the word will. The authors describe the standards that you have to meet, but in the opinion letter itself, you're supposed to reach or meet certain ethical standards. And in the case of if you're CPA, which many of you are, on page 155, 156, this comes from our SSTS. If you look on page 156, these are the guidelines. You're supposed to establish the relevant background facts, consider reasonableness of assumptions, consider applicable regulations and standards, apply authorities, consider the business purpose and economic substance, consider whether the issue involves a listed transaction, consider other regulations and standards applicable to written tax advice, and arrive at a conclusion. So you can see, it's supposed to be, obviously, when you're writing about a challenging tax issue, one of the things that the AI standards, Peter, to get to your issue, these are supposed to be the guideposts of what constitutes a well-grounded opinion letter. Now you might say, is there a violation associated with failing to meet up to the standard, right? Because that's one of the metrics for how you know, how compliant you will be. There's no penalty, you might say, oh gee, that's best practices, but who cares, right? I forewarned you, there probably is no monetary penalty. The AICPA is never gonna censor you, never gonna strip you of your license, or any parade of horribles will come if you craft a poor opinion letter, okay? So I guess that's the good news, that the parade of horribles will not follow. However, you want to fill in the blank? If you fail, Omari, to follow these various steps, what's the biggest risk you run?
The client will sue you
Sue you for what?
for malpractice.
Potentially. I mean, obviously, potentially. And let me give you a little foreshadowing about what will the client have to prove if you fall short of the mark here in terms of your opinion letter. In other words, the client's kind of irked. You wrote a shoddy letter, right?
We're incompetent?
You're incompetent.
Right.
Is that grounds to sue you? What is an essential element of any malpractice suit? Just to give you, again, a little foreshadowing for chapter 6. So what do you have to show, Dixie? Any thoughts here of what you have to show?
Maybe intent.
There's no intent. Generally, you know, no one's malicious, generally, when it comes to these issues. Let me just see if you have that door. So no one's malicious. What is the essential element? Kevin, can you get through? All right. You're in good shape.
Let's see if I'm a good driver.
Kevin, I trust your driving ability. All right. So, as Kevin's getting situated, thank you, B.
Sure.
We're talking about an essential element that if you craft a poor opinion letter, and the client's not happy, the client's going to sue you, but what does the client have to show to be successful? Because they're mad at you, but getting mad and suing you may not get you through the door. What do they have to show? I'm not trying to be cryptic. I'm trying to get you guys to think. What do clients have to show before they get into that world of malpractice?
Intent.
No, because I just said intent doesn't. Most accountants harbor no ill intent towards their clients. So what does the client have to show? And I'll give you a very big hint here. It starts with the letter D.
Duty of care.
Say again?
Is it duty of care?
Due diligence.
Well, they have to show duty of care, but something else.
Due diligence.
Damage.
Due diligence? Yeah, but even if they're not that diligent, you probably still can't get through the door unless you show damages. Okay? That's, I mean, right? Omari, they could be mad up the wazoo. The letter you wrote has misspellings, it has typos, it has this, it has that. You know, it has a million things that are flawed. But at the end of the day, if they paid the right tax liability, you know what? Who cares?
Right.
All right, everyone agree? But if they had to pay a 40% accuracy related penalty, now they care. Right? But they have a duty to show, you know, to get through the door of a malpractice suit. They must show damages. And I will allude again more in chapter 6. Sometimes clients are torn because they invested in a tax shelter and they are now being audited by the IRS and they want to potentially sue the accountant who got them involved in the tax shelter. And they know what is generally the statute of limitations, Omari?
Is it 3 years?
Is that right, Nick?
6.
6, generally 6. Painful years, okay? Many people, including myself, might argue 2 years is more appropriate. You guys be, I think we'll, in this room, we'll all be on the same page on that one, right? How about 2 days? Right?
That's even better.
All right, 6 years, a long time. Anyway, and that's typically from discovery. But picture, if you will, client is irked because they're involved in a tax shelter and the IRS is coming down hard and heavy, and the statute of limitations now might be beginning. On the other hand, if they try to bring a lawsuit, what might a judge say? Hey, this case is, the word is ripe, right? Because you don't know what the damages are. So the client is sitting on his, her, or its hands because they want to commence a lawsuit, but they're missing this essential element of damages, right? So right now it's only hypothetical, right? There may be damages, there may not be. So clients are in an interesting position. All right, so the point I want to raise with you, that yes, the AICPA has its rules about what is an opinion letter, but as a practical matter, enforcement is not going to be high. You know, the AICPA and bar associations are chasing down derelict practitioners who are stealing money from escrow accounts and things like that, right? That's where they're spending their resources on. They're not really worried about the kind of letter you're crafting, right? So I will say this, though, I get back to, if you do commit malpractice and your letter, your opinion letter is shoddy, what does the plaintiff's attorney say? You know, having just been in a room with 12 members of the jury, you know, the first thing the lawyer will do is say, members of the jury, please, I'm going to distribute to you as Exhibit 311 this opinion letter, and it's just replete with typos and all sorts of other stuff. And they see your shoddy work. Even if they don't understand the nature of the malpractice, they're going to extrapolate that shoddy work and say, this guy must have done something wrong because they can't write a coherent opinion letter. All right, so just my message to you, when you're crafting something to your client, always be on notice, make it clean, make it good, make it perfect, okay guys? No excuse for shoddiness, because those things today may not matter, but tomorrow could come back to haunt you, big time. Does Circular 230 apply in this context? Does Circular 230 suggest the parameters of what should be in an opinion letter, Mike? Is that a yes, Mike? Or Viva, you say yes? Okay, it does, right? Does it apply anymore?
No.
Probably not, right? Under Loving and Ridgely, the opinion letter, Circular 230 is that practice before the IRS? Right? Are you playing the role of a representative? And the answer is probably not. You're not practicing before the Treasury Department. You know, once again, Circular 230 was crafted in 2010, the last version, prior to the outcome of these cases. So, notwithstanding what's in the book, but I think the authors raise it too, this may have far less relevance. But, again, I am telling you that people on juries, when they look at ethical standards, even if you might argue, someone might argue on your behalf, well, there's court cases that say these ethical rules don't really apply. Juries, they see ethical rules and they're going to be programmed to try to apply them. I'm just letting you know. So, but the AICPA rules are pretty clear, and they do apply, that your opinion letter should have these various elements. So, again, spelled out on page 156. All right, everyone's got those? All right. So we're moving on to an interesting topic. I think it's interesting. Client confidentiality and evidentiary privileges. And if you recall, towards the beginning, or at the very end, I should say, of class last time, that I just said that just like chapter 3, or chapter 2, excuse me, is bifurcated into two kinds of penalties, those applicable to taxpayers, those applicable to tax return preparers, very different kind of penalties. Chapter 4 is bifurcated into two parts, right? John, you recall those two parts?
Kind of exactly how the chapter's name.
Okay, well, you tell me.
The first half, confidentiality, and second being evidentiary purposes.
I don't know if you would frame it that way.
Work product
It's
doctrine.
work related and the client relationship.
Say, what are the two, privilege one?
A client relationship.
When you say client relation, just be, words matter here.
Attorney client relationship.
Well, let's call it client confidentiality.
Yes. And second is lawyers work related.
Well, the adjective lawyer,
Is it work product doctrine?
work product doctrine, okay? So there's two different potential privileges, plural. Two different privileges here that can be invoked to limit access to information. The first is client confidentiality. And we see that that can extend both in the legal sphere as well as the accounting sphere. And we have the work product doctrine, okay, the work product doctrine. And that too is another privilege. And what we learn is the attorney-client privilege, the client privilege, that is a very, very tough standard to overcome. Very hard standard for someone to get access to information that was spoken supposedly in confidence between a client and an attorney. And I'll say parenthetically that confidentiality standard was augmented by Code Section 7525, right? Code section that's supposed to, in a limited fashion, extend client confidentiality between clients and accountants. Code Section 7525. And then, in addition, we had the work product doctrine, but that doctrine is a qualified evidentiary standard, and it is somewhat easier to overcome. If you can prove sufficient need, you can, they call it a conditional privilege on page 160. The first paragraph on page 160, a conditional privilege. If the party seeking disclosure makes a sufficient showing of need for the protected evidence, the court may order disclosure. All right, and let's talk about client confidentiality. I just want people to know, again, for tonight's purposes, largely, we're going to talk about the rules of confidentiality. For Saturday, we're definitely going to get through the work product doctrine and again, get a bit into chapter 5, for sure. All right. And for those who came in a bit late, there's two, let me just see. Anyone, I didn't get,
I got one in the letter.
okay, you got one, but you didn't get two. I have two things, one dealing with model rule and a so-called Cobble letter. So, everyone will give you those two. Now, Viva asked about the model rules for the exam. You don't have to have the entirety of the model rules, just the one, there's a few that the authors mentioned. And so model rules, all you have to do is type in the model rule into Google. First thing that comes up is the model rule, whatever you type in. So these are not hard to find. In fact, if you just want to have them there, that'd be great. Let's look at model rule 1.6. Again, I handed this, everyone should have a copy of this. It says a lawyer should not reveal information relating to the representation of a client unless the client gives informed consent. The disclosure is impliedly authorized in order to carry out the representation or disclosures permitted in paragraph B. And B has certain exceptions. Now, this is somewhat replicated if you turn into Appendix K. Appendix K. Have it available. This is the AICPA Code of Professional Conduct, entitled Confidential Client Information. A member in public practice shall not disclose any confidential information without the specific consent of the client. All right, everyone see that? So, when in doubt, and for exam purposes, or for you guys outside the classroom, at mum's the word, okay? Like, when in doubt, the strong bias is to not make disclosure, right? Everyone agree? All right, so bearing that mantra in mind, let's look at these 4 problems the author has posited. See if we all come up with the same conclusion. We have Holly is a business lawyer who handles tax planning and related transactional matters for Miracle Ventures, an S corporation engaged in organizing travel adventures for religious groups, and the sole owner of Miracle Ventures, Penelope. During a recent meeting in which Holly suggested transferring some of the stock, the Miracle did trust for Penelope's children, who are 9 and 11. Penelope mentioned that she has recently met with a divorce attorney because she's thinking about whether to file for divorce. Holly asked Penelope, who Penelope had consulted. Penelope said, Harry Smith in Redwood City is supposed to be tough, but sensible and reasonable. I think he gave me some good advice. Holly had never heard of Harry Smith before Penelope mentioned him, and has done no follow-up research on Harry. The following week, a business associate of Holly and Penelope, Bill, says to Holly at the cocktail party, have you heard that Penelope and Travis, that's the husband, are having problems? So, what is Holly to say in response? So, Kevin, any thoughts here on, and B, see if you, what do you say here? Response.
Honestly, I wouldn't know.
Don't know, B?
Holly should say nothing. I mean, feign surprise or say okay.
So I like the word feign, right? Feign surprise. Everyone agree?
I mean, I think that it falls into it because even though it wasn't given to the lawyer as a client type of interaction, it was still in confidence.
Right.
So because it was in confidence, it's still protected. That make sense?
Yeah. I mean, in this kind of situation, you're supposed to keep the client information confidential. Client harbors, I've had many clients say to me throughout the years, oh, what I say to you is in confidence, but I know even if they don't, but I've heard that line many times, people harbor that expectation anyway, even if they don't verbally say it. Question B. Instead, suppose that Bill approaches Holly at the cocktail party and asks if she can recommend a tough but reasonable divorce attorney. Can Holly recommend Harry Smith? Assuming she does recommend Holly, what can Holly say if Bill asks Holly what she knows about him? So, in this case, what do you say, Gus? What can be said here? Of anything?
I think is, as long as she keeps the information is confidential, she just recommends the lawyer, just purely recommendation, I think it's okay.
Is this a good place for her to recommend?
But she probably doesn't know him because.
Well, she doesn't know this attorney, right?
No.
So, what do you do here?
Did you recommend?
You can't do nothing because,
No,
like,
she cannot recommend, she can recommend another guy.
I know.
She
Well-
knows that. She cannot tell him that.
can she recommend Harry Smith is the question.
I would say no, because it's still the same. Indirectly, by mentioning Harry's name, there's already information that was given, you know, to him by his client,
Right?
So I think that's still the same rule applies.
Yeah, if you look on page 160, guys, under Roman numeral 2, the first paragraph, the last line, it says comment 4, that's a rule 1.6, notes that the prohibition applies not only to a disclosure of the protected information itself, but also to any disclosure that quote unquote could reasonably lead to the discovery of such information by a third person. So theoretically, by you making this recommendation, there's a chance that this will lead, people can connect dots. And if they can connect dots, you may put Penelope in a very, very awkward situation. All right?
But if she did already know this guy prior.
I mean, if you knew him prior, then it should be okay. I mean, you get into an awkward situation because if you recommend someone that you don't know personally, and you recommend it based on someone else's recommendation, it's a wild card. Are you really doing your client a service? All right? So again, I think the takeaway from problem 4.1, guys, is not to say anything at all. And truly, it behooves you because you really don't know this person, and they may not be very good. And how many times have you heard clients rave about someone, and 2 weeks later, 3 weeks later says, I was really wrong about that person. So you don't want to be, then what do? Call your client up and say, you know that person I didn't know who I just recommended? I heard some bad things. So, you know, clients, if you're going to recommend someone, really think the expectation is you really know that person. Four point two. Jan and Earl are having lunch at a local pub. Myra, a waitress at the pub, knows them and knows that Jan is a tax lawyer because she represented her in an audit last year. Earl is a plumber. She saunters up to the pair, and after an exchange of greetings, says, Jan, a couple of the girls say that the IRS says we need to report our tips. Is that right? Jan responds, sure is. Myra then asks, they really audit this kind of stuff. I mean, how likely is it that I'll get in trouble if I don't report my cash tips? Jan tells Myra she doesn't know. Can Jan disclose this conversation to anyone? So, in this context, what do you think here, Ming?
Jay, I think no. She
She can't.
can't tell anything.
And Ping, do you agree?
I think this is general because the tip, be reported, which is a general idea.
Well, you're
And it's
saying
not-
Code Section 61, it's sort of general knowledge, right?
General knowledge, you can say.
Sky is
but
blue,
you don't
you
want to
can
mention
repeat that.
anyone in detail.
Can you mention the conversation you had specifically with the waitress, Myra? Can you
Myra
say,
can decide.
say again?
No, she cannot disclose the information which she converted with the Myra.
So she can't disclose this information. Just be careful because, go ahead, Peter.
I think she can because
Yes,
it does say that it was,
Client.
that he represented her in a prior audit, so that audit is non-vote is done, so he's no longer.
Be careful, Bill,
representing
because do you have obligations to your
Past clients?
past clients? And V, you're shaking your head, yes or no?
Oh, do we have obligation? Yes, we do.
Yes.
Okay.
But, I mean, but my answer to both is like no.
No what?
The lawyer should shut up.
Okay. But what is the client confidentiality, what is that premised upon? There has to be an expectation on the speaker's part that there's an intention to keep things confidential, right? Everyone agree that a predicate to the attorney-client privilege is an expectation of privacy, right? Do you think Myra, who's in the middle of a diner, who marches up to her attorney and Earl the plumber, is harboring an expectation of privacy?
No.
Probably not. So I don't think Myra, no offense to Myra, should harbor an expectation of privacy here about this conversation. Everyone agree? The context, my point is, I applaud you, V, for thinking confidentiality, and you heard me say, when in doubt, mum's the word, but you can't go overboard, right? Because there are limitations of when it's, you can't say, I can't say a word about that conversation because I'm an attorney. Because anytime you have a conversation with an attorney, is it meant to be held in confidence?
But if Jan talks about it, is Jan a guy or a girl?
What?
Jan is a woman or a?
I assume a woman.
Okay, so, I mean, Jan knows that if she speaks about Myra, then Myra could get into trouble. Why would she?
But when there's a third person, the expectation
She
of
doesn't do it.
confidentiality goes out the window.
Yeah, I mean, when you do have a third person, Earl the plumber, this role of confidentiality is subverted.
If she does it in private, then it will be.
If it was said in private, then wholly different. Where
Maybe
does-
Jan and Earl are seeing each other and they don't keep anything from each other. Just joking.
Assuming Myra says she's gonna report her tips, can Jan tell the IRS that the other waitresses are not reporting theirs? What do you say if, Andrew, what do you think in that context? And Maury, see if you agree with Andrew.
I'm not sure if Mira is saying she's going to report her tips would dictate whether or not she could tell the IRS if she has reasonable suspicion that the other waitresses aren't reporting tips. So I guess, yeah, Jan can tell the IRS that.
Because there's no, in your opinion, violation of attorney-client privilege. And
Well,
B, you're shaking your head, what's the problem?
How would she know?
I mean, this disclosure could reasonably lead to the discovery of such information. I mean,
What information?
sorry, I mean,
The thing is, she's not the client. The other
Yeah.
people aren't the clients, so
It's
it
true.
doesn't matter.
Omar, you were gonna say?
I was gonna say, how does Jan know about the others? The others' business?
I mean, she may know what the general practice is among her colleagues, right?
With Myra?
Yeah, I mean.
Cause I'm thinking she's going into a restaurant and basically dining and someone.
No, I know,
Myra's telling
Jan
her-
may not know, but vis-a-vis Myra, she may learn of the other waitresses aren't.
But can you use somebody else's word to tell on somebody else? I don't think so.
Let me just see if someone's locked out.
Is this a class of business communication?
No. Right. Is he asking for a class on business combinations?
Computation.
Okay. So, look, clients have, if clients say certain things to you, again, in confidence, you cannot repeat those things, right? Because that would be a violation of Rule 1.6. So, I don't think, and again, I'm not trying to be equivocal for your notes, because most people in this room, including myself, like black and white answers. Heck, that's what we signed up for. But when it comes to some of these ethical issues, right, there's certainly shades of gray. So we would like to know more, right? If this was truly said in confidence, if it was said in confidence, then it would be restrictive on Jan's part. She should not make any disclosure. If it was not said in confidence, right, then I think we're back to where Jan has more flexibility to make disclosure. So again, I'm not looking to make your notes ambiguous, but I do think you gotta look at more closely, and I'm not sure if we have enough facts here to say whether or not this disclosure was made in confidence or not.
So does it not matter that not reporting your tips is against the law?
I'm not sure what your question is. We know not reporting your tips is dereliction of duty. Keep going.
Right. So that's still in violation of 1.6 then?
What is in violation? Because the failure to report wages has nothing to do with 1.6.
Okay.
1.6 only has to do with the interaction between the attorney and the client.
Okay.
But let's just say, face reality. Myra comes to Jan and says, you know, I haven't reported income for the last 4 years. What can Jan, the attorney, do with that information?
Advise her to
Yeah,
report
she
it.
can advise her to.
Advise her to comply, and if she doesn't, she has to withdraw from representation, but what she can't do is disclose it, right?
Yeah.
When you say withdraw from representation, you also mean not preparing tax returns.
Yeah, withdraw and not prepare any tax returns.
So in answer B, we need more information.
We need more information for probably, so.
So yes, she could show up. There's no violation.
Assuming that Myra did not tell Jan something in confidence about her coworkers. Jose represents the estate of Flyer. By the way, did someone's plane, some sports star go down today?
Yeah.
Who was that? I didn't.
It's a soccer player, I forgot his name.
Was he flying the plane himself?
I don't know if he was flying the plane, but they lost him over the summer.
Yeah,
Rescue
they-
mission, when the rescue mission is over, just recovery mission now.
Yeah, that's what it's kind of sad.
Emiliano Sala.
Who did he play for?
Sala or Sala. Cardiff City striker. Cardiff City in the UK.
Okay.
Yeah. It's disappeared.
I'm sorry, yeah, it disappeared. Just so everyone knows, I have my phone on and I don't know we have a snack coming at 7, and Kevin was kind enough, he insisted that he get the class pizza. So we have not me to thank, we have Kevin to thank, but he was insistent. So I don't know, Kevin, if they're gonna call you or me.
They're gonna call you, I gave your number.
Thank you. So, if you heard my phone is on, now you know why. Good, thank you, Kevin.
You're welcome.
All right, Jose represents the estate of Flyer, an airline pilot who flew and showed World War II, or fighter plane at air shows for a number of years before the plane crashed with sadly Flyer in it. Flyer won a number of substantial prizes at the air shows and treated his air show activities as a trade or business. The IRS, after audit, denied the related deductions on the grounds the activities did not constitute a trade or business or profit-oriented activity, but rather amounted to merely a hobby. So hobbies, I believe, are under Code Section 183, where you have to show profits for at least, I think it's 3 out of 5 years, or else you can't take losses, okay? Where does this come up? A lot of people, quote unquote, seek to make money in horse breeding, dog breeding, all those sort of things, but they really do it because they love that activity, they don't do it as a real business. And, Congress don't want people who enjoy, deduct their personal expense, essentially what, a hobby expense, right?
For that rule, 3 out of 5 year, I just wonder how enforceable that is. 'Cause I think like business or like restaurants, for example, lose money for so many years the first few.
I have not had a hobby issue come up for years, so I haven't looked at that issue.
Okay, yeah, 'cause I just know like certain types of businesses are known for losing money for the first few years.
Yeah, I hear you, restaurants are notorious.
Right.
What section covers the hobby?
Now you got me, I gotta look, 183, I'm sure, it's either 183 or 185, but now, I wanna look for my,
Or
I
if
haven't
the
had,
activity is not engaged for profit.
yeah. Okay, it's code section 183. Yeah, and I'm right, it's 183D says, the gross income derived from an activity for 3 or more of the taxable years in the period of 5 consecutive years. Right. And I think, by the way, this is just a presumption that we can overcome. And I think it's easy enough when you're in the restaurant business, you ain't
Right.
doing it for fun.
Yeah,
Working
'cause-
7 days a week.
Cause the other one I think of is like the logging industry. If you decided you bought a plot of land and want to start growing trees to log, you're not seeing revenue for
Right.
a decade,
But
then
again,
profit.
I haven't had this issue come up, so it's a presumption, I think taxpayers in logging or restaurants or you name it, and say, look,
So-
no one's doing this for fun.
Right, so it's not a hard fast, if you don't get 3 out of 5, you're done.
I don't, again, I would look at it more closely, but
Right.
notice that the word presumption is
Mhm.
used. All right, in building the case for the estate, Jose, has obtained a number of magazines relating to flying and air shows, some of which include pictures of flyer and his plane and text about flyers flying. All the magazines include information about the prizes that can be won at air shows. Can Jose let his son Timmy, who builds and flies model planes, see the magazines?
That's a good question.
All right, so at some point, Peter, you're gonna say,
I would say no, because if he's under audit, if that's the information that he's using, I guess, to represent.
he's just showing his son.
Yeah, but, well, what if his son somehow gets that information, what if that information is harmful to his client, and then accidentally his son somehow discloses it? That's the way I thought about it.
Are these just general magazines that are available to the public that you could have theoretically at some point or another purchased?
Okay, at the library.
Right, I mean, that's not, that's public information.
All right. Anyone have any other opinion? Let's face it, guys. Your children may not consider your career that exciting. I know this comes as a surprise to some in the room that last I checked, you're not rock stars of sorts, so it's not like, so you have very
Nobody
little.
makes jokes about accountants being boring, come on.
I did see the first few minutes, I thought as a duty to this class, guys, I would watch the whole movie, but I did not. But I have to say, the first few minutes, it's definitely a male
The
movie.
accounting.
The Accountant is,
Oh,
It
yeah,
was a
Ben
pretty good
Affleck, right?
movie.
That taught
Yeah.
a lot of tax shop. It was a good movie.
it's a good movie, I saw the first few minutes.
It was a good movie.
And I have to say that, who is it, Ben Affleck?
Ben
Yeah.
Affleck,
Ben
yeah.
Affleck.
He looks well built for the movie, let's put it that way. So, and it's not like he decides to take anyone prisoner, it just seems in the 5 minutes I saw, if you're in his way, you get a bullet in your head,
Yeah.
essentially.
Pretty much the whole movie.
Okay. And it's funny because someone said to my wife and me, they said, they said, the funniest 5 minutes of a movie, and this is what they said, and then I had to see it for myself, and I'm gonna disagree. Gotta see, what is it, Perfect Pitch Perfect 2, the second, not the first, not the third. The first 5 minutes. Did anyone see it? Because I'm sorry, I did not find, it was about a wardrobe malfunction, let's put it that way. And like this they found funny, and the woman who stars in that, I think is in The Accountant. She stars in.
Anne Hathaway?
No.
I don't think she was in there.
So, anyway.
That's why I said it like that.
I watch Ozark too.
Is that about an accountant?
Yeah.
Which
It's
one?
about,
Launders,
money
for the
laundering.
cartel.
Okay, it's called Ozark.
Ozark.
It's
on
a series
Netflix.
on Netflix.
Oh, okay.
On season,
Yeah.
it's going on season 3.
Season 1 is better than season 2.
All right, before we go down that,
Hey.
we're back to Flyer. Can Flyer show this to son Timothy? And I actually spoke to Michael Lang and Linda saying, guys, what are we getting at with this? And just so you know, they have a difference of opinion, okay? Michael says you can disclose it. Like, when I say disclose it, show it to your son. There's no harm. You show him in a magazine. Linda was more circumspect and said, you know, I wouldn't go there because this can end up in some form or fashion. Your son, I don't, how old is the son here, they say? You know, let's suppose it's a younger son. You never know what they'll do with the information.
Well, that's how I thought it.
All right, so, but if you look at the second part of the question, Michael and Linda were on the same page. Can Jose share the magazines with Timothy's teacher, a longtime fan of their shows? And there you get into the problem of, by showing, and then the teacher's next question might be, well, how did you get, why would you have these magazines? You can extrapolate that there must be, or might be a controversy, and might lead to some sort of inadvertent disclosure which you're supposed to stay away from. So again, I'm not trying to make your notes ambiguous, but question 1, the authors themselves have a difference of opinion about what they would do. Question 2, or the second part, they were both vehement that shouldn't make any disclosure to Timothy's teacher. Problem 4-4. Michelle, representing Tommy on audit, the IRS has taken the position that a series of trips from New York to Miami were personal rather than business, noting that most of them occurred between November and May. Tommy provides Michelle both detailed information about business conducted on each trip, including the names and some of the business contacts. In checking some of the information provided, Michelle inadvertently learns that one of the business contacts that learns from one of the business contacts that Tommy's significant other lives in Coral Gables near the University of Miami. Can this information be disclosed to the IRS? If so, under what circumstances? So B, once again, you're saying no. Dixie, do you agree with
Yeah.
and Dixie, why?
Because he's representing the audit.
Say again?
He's representing the audit.
Yeah.
So you say, what's your authority for non-disclosure? What would you cite to?
Six.
7.5.
Model 1.6.
Model Rule 1.6, and if you're an accountant, you would cite to the rule found in Appendix K, right? Now, here's an issue though. Did the client communicate this did the client communicate this information to you, to the attorney here, Michelle?
No.
Okay, so there's a concern here on your part, right? Because client communications are confidential, here the attorney learned the information outside, right? Right? She learned it inadvertently, right? Everyone agree? Now, she learned it in the context of the attorney-client relationship, but it was not, let's put it this way, the client would have been better served by communicating this to the attorney, right? Because then there's clearly communication, than her learning it inadvertently. Now, keep in mind, when we look at Rule 1.6, which everyone has, 1.6b has certain exceptions, right? Certain exceptions. And I don't think, well, look at 1.6b2. To prevent the client from committing a crime or fraud that is reasonably certain to result in a substantial injury to the financial interest or property of another, including the U.S. government, and in furtherance of which the client has used or is using the lawyer's services.
Then yes.
Well, you know, if the client is not being forthcoming, and look at look at rule right below that I distributed, 4.1b. In the course of representing a client, a lawyer shall not knowingly fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by the client, unless disclosure is prohibited by Rule 1.6. So, sort of circular. So, the lawyer is in a tough position, right? Because Rule 4.1 seems to imply that, hey, you can't lie to the attorney shouldn't lie to the IRS. The attorney now knows something material, right? That the client is fraudulently, potentially not disclosing and potentially fraudulently not disclosing. However, Rule 1.6 says that you should maintain client confidentiality, right? So, you guys are really gonna not like when I say things, but I think there's a real tension here between the rules. Because on one hand, you're supposed to make disclosure if someone's perpetuating a fraud. On the other hand, client confidentiality is paramount. What do you do in this situation? What would I do? And you're gonna see, in a few minutes, I'm gonna talk about something I lived through, but if you can, call the ethics hotline, I kid you not. When in doubt, I would say you hold it you would hold it confidential. I mean, I would create a memo to the file saying to the client, hey, I learned about this, I think you should disclose, right? Yes. And we have to reposition ourselves. And if the client doesn't listen to you, I think you withdraw from representation and move on in life.
So you wouldn't recommend for the lawyer or DBA to go directly then?
I think you're asking for trouble.
Okay.
I think if you do it,
You do have backup though.
When you say the backup is just run for the hills and say to the client, I can't represent. If the client is, if the client puts you in an awkward position where you learn about this and wants you to keep your mouth shut and you're going before the IRS, you know at some point, if something happens, you're gonna be blamed that the client's gonna say, you told them to be quiet. So the best you can do is either let the client say, you're right, I will have to do it, or you gotta get out. No good will come. And when the bad comes, you can't use it as an excuse to, there's just gonna be no plausible excuse on your part. Let me give you my quick story here that's worth just as hard as you try to practice ethically, watch what kind of situation you could be thrown in. A gentleman comes to us, this goes back 10 years ago. Unfortunately, his wife died, so we helped handle his wife's estate. Fast forward, several years later, he finds a girlfriend, and he decides he's going to marry her, right? I told you, yes, his wife died, so he's gonna marry her. And they have the marriage date all set, he's gonna get married, and he unfortunately finds out that he, like, several weeks before the wedding, he has brain cancer, okay? So he wants to still get married, and he's gonna, and he does, and he's gonna have a new will drafted, and we drafted the new will for him, and he's leaving it all to his children, okay? He's gonna leave it 60-40 between his two children because one had gotten more money during life, so for whatever reason, 60-40, right? And he is going to be, and his, by the way, his new wife is not any slouch. She's a high power attorney in Philadelphia, okay? So get the visual. And she, he's going down to have surgery performed in down in Philadelphia, and he asks us, he sends an email, can we send him a draft of his will to review? And we send down the draft and everything looks good. And then he says he was gonna get it executed down in Philadelphia, where up here he can't get it done. So we send him the execution copy. And he's gonna be operated in on the following week or 3 days later. Anyway, and his new wife, who's an attorney, is gonna get everything, the documents signed, notarized, witness, it's all gonna be taken care of. Anyway, he goes in for surgery after signing the will and literally lapses into a coma and dies. And she sends back the will to us and says, don't worry, I took care of everything and I made 1 or 2 small changes. Well, what do you think the will said?
That she was
That
entitled.
she's-
She gets nothing.
That she gets everything instead
She
of
gets
him.
everything. She gets
Yeah.
everything.
Yeah, she can have
The will's recrafted where
She
she
did
gets
that.
everything. So you guys, what do you do in that situation? When you get the will back, and literally, verbally, she said she made 1 or 2 small changes, and you open the will, and the will that you crafted, leaving it to the children, is been changed to leave her everything. What do you do in that
You
circumstance?
inform the children? Because in some way you have a duty to the children, right?
Do you?
No, not to the children, to the father.
I
That
mean,
was
but
your
the father
client.
is,
He's dead.
he's
Yeah,
not,
but
to.
yeah.
I
But then,
would,
through the father, it's your duty to make sure that the father's
will.
wishes are respected and followed.
Why,
Right.
is it a spiritual kind of thing?
No, you're his lawyer.
Yeah.
I mean, you theoretically represent the state now.
I mean,
Yes.
first of all, I almost passed out, because like, I have to tell you, because when you read something like that, you're like, and this is not some, like I said, this is a very high-power attorney in Philadelphia, and you're like, how could someone do this? Like,
Because she's a very powerful attorney in Philadelphia, that's why she did it.
well, her mentality, I'll tell you later, was, hey, I'm here, I was taking care of him, his kids were paying attention to, you know, they had their busy lives, I was changing his bedpan, and,
So what?
well, you know, her flaws, she had convinced herself, she was there for him, where were they?
Why did she even marry him?
Well, we found out later, within a week, she was back on the dating site. And this is like her 4th husband. She was truly the Black Widow, gold digger. Okay, so, but so the first thing I truly did do with my colleague is we did call up the 800 attorney ethics hotline, because what do you do in that situation? And I really thought we should call the police. I mean, this seemed to us like a crime. Literally, someone was stealing several $1 million. And the attorney's hotline said, you can't disclose this because it says if a crime would be committed, if there was a crime, it had been committed, right? Do you understand the distinction? It wasn't like making this call would stop a crime, right? So we let it play itself out. And what I mean by let it say, because we had the original will, his kids, I forget how they did it. If she was named herself as executrix, and then her kids, they obviously quickly found out about the terms of the will, quickly brought a lawsuit, and then there was a battle royale between them.
I hope they won.
They ultimately settled. I would have, if I were her, with my professional license and reputation on the line. I am a very weak person. I would have said, I'm out of here. You guys, I'm sorry. I had a moment of lapse. Let's just move on. It's your money, and I'll go on. She held firm, and I don't know what the ultimate settlement was. I was deposed. My colleague was deposed. It never, to my knowledge, went to trial, but they settled, and she probably did very well for herself.
But she was supposed to get 1/3 anyway, right? If he left it all to the kids.
I forget, if there was a prenuptial or not. I just
Okay.
don't remember.
Okay.
This goes back 5 or 6 years ago. But be that as it may, the will was fundamentally altered. And like I said, you're gonna come across this, guys, in your practices where you think I expected that, and then you revisit things and you say, gee, did I make a mistake by sending a document in Word form? Should I have sent it in PDF? Was I did I do something to put this in a compromising situation? All these kind of things can happen in your practice where you will get broadsided or blindsided because you just can't believe what some people might be capable of doing. Your brain doesn't go there, and when it happens, it's pretty incredible. So just be forewarned. It's a dangerous world out there. I know, Penny, you don't need to be reminded of that, but.
Because I'm working at the healthcare, so we do have, HIPAA. So it's kind of, the patient information we cannot disclose, or we cannot see.
Right, HIPAA rules.
Yeah, HIPAA rules. It's also similar to this one.
What was that last part?
Similar to, professionals, so
Right,
not
right.
disclose every important information.
Right.
Yeah, same thing with universities.
Yes.
Absolutely.
Yeah, you can't disclose any student information.
Yes, they say it's like if you are not work on that account, you cannot see patients, medical record, because you are not working for that patient. So,
All right, so, anyway, these issues of confidentiality do come up. I'm not gonna say daily or weekly or even monthly, but every 2 or 3 years, you're gonna have, in my opinion, an issue about confidentiality that may come up. And particularly with the demographics and the graying of the population, and you have elderly, and their children come in, and their children want information. And who's the client? Should you disclose that information to the children? Particularly when you're shaking your head, Peg, but there's some situations where you can't win because the people really want their kids to know, and then you have siblings who are fighting. All right. Exception where disclosure is required. Notice the word required. Okay? So problem 4-5. You have Larry Lawyer is representing A and B, the two shareholders of an S corporation, in a case raising questions about whether the S corporation's gross income, which is allocated 50-50 between the two. The case is now before the tax court, but since A and B live in different regions, A's case would be appealable to the Ninth Circuit Court of Appeals, while B's would be appealable to the 2nd Circuit. Okay, so the Ninth Circuit is out in California. And if I'm not mistaken, I think New York is 2nd Circuit, right? Okay. The Ninth Circuit has a rule stating its unpublished opinions issued prior to 2007 may not be cited as precedent, but the 2nd Circuit does not. It just so happens the 2005 unpublished Ninth Circuit opinion that is directly adverse to the position of A and B has not been cited or mentioned by the IRS counsel. Should Larry disclose this to the court? Okay, so everyone had a visual, there's an adverse opinion, and if you look at the, under capital letter B, exception where disclosure is required, Model Rule 3.3, A2 requires a lawyer to disclose to, quote unquote, the tribunal, legal authority, and the controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by opposing counsel. Right? You're supposed to, notwithstanding that you're supposed to be an advocate for your client, you're also supposed to be, hey, in search of the truth, right? So, yeah, this dual existence, do you have any obligation to make disclosure? And it points out, they cite to this ABA informal opinion, suggesting that this model rule would apply, even though the decision is not from a court with reviewing authority over the trial court. Is this a fair reading of the rule? So, would you make this disclosure?
You have to.
You would have to. Now keep in mind, and this is the quandary. Remember, the Ninth Circuit seems to be alluding that it may not, that you're not supposed to be citing to unpublished opinions issued prior to 2007, and last I checked my calendar, 2005 is before 2007, right? So argumentatively, I mean, you get into a tricky situation. You might, again, I know this sounds kind of like a, how do I say, like I'm chickening out, which is a fair statement in your part, but I would call two things I personally do. I would call the ethics, I know this, there are ethics hotlines, guys, you can call them and ask them what you should do. And then, if you don't mind me saying, because all you don't want to be potentially as a CPA or a lawyer, you don't want to be stripped or censored for your license, right? You don't want to make a mistake. And here's the kind of situation where, if you don't mind me saying, it might be worth $1,000, $2,000, $3,000 to talk to a lawyer who specializes in legal ethics or accounting ethics and get an opinion letter, one pager. And in my opinion, I know it's just my philosophy, practice from defense. Like, if you do that and you're wrong, nothing, in my opinion, nothing's gonna happen. You went through, did your due diligence, and you created a real effective silo against anyone challenging your behavior. If you don't do that, and I mean, I've spent a lot of time studying legal ethics. I don't think I'm an expert in that area. No offense to you guys, you're not experts in accounting ethics. So don't leave it up to yourself to decide how these rules should apply, right? Just know you have an issue, and sometimes you have to reach into your own pocket to protect yourself. So it's a security blanket, but if you do that, the CPA licensing board is not going to do anything to you because you exercise good faith. So for your notes and for your out of the classroom experience, just know when you get into a really challenging ethics issue, you do have recourse to try to reach, and if you don't get a satisfying answer from the ethics hotline, you should seek private counsel who specializes. And if something happens, when something goes wrong there, I hate to use the M word, but you have a malpractice case against the attorneys who rendered an opinion, right? Who said ethically you should disclose or ethically you should not disclose. And if something horrific happens, Omri, what do you have?
Something what happens?
If something horrific happens where the attorney rendering the opinion was wrong, what do you have?
Malpractice or potential lawsuit?
Because you have?
Damages.
That's the word I was looking for. You have damages, right?
Right.
Suppose your license is suspended for 6 months. Boy, you have lots of damages. Not just that 6 months, but just think about your reputation.
Loss of income.
Oh my God, I mean,
Yeah.
and that was be illegitimate if that attorney rendered bad advice. You get real recourse.
Right.
You know, just like many of you, everyone in this room has car insurance, right? Everyone in this room, you know, you get insurance, not because it's gonna happen, because if you don't get it, it might happen. And then I have to ask you guys, because in your car insurance, what kind of threshold? Just name some numbers. How much,
100.
sadly,
100, 300.
you have 100, 300.
I have a high coverage, yeah.
Anyone have higher?
Higher than 100?
And what's your liability coverage if you run someone over tonight?
That's
Brian,
maximum
how much you covered for?
The maximum that it can be.
What is the maximum?
I don't remember the number.
You like what, 50,000 or something like that, 100,000?
Listen, maybe all you guys should call Uber tonight on your way home, because call me risk adverse. Be careful about the word, Brian, the most. These are numbers you should know, because if you do get into an accident, everyone have an accident in this room at least once?
I have a story. I was sued.
Yeah.
And it went to trial.
Really?
Yeah.
How much were you sued?
I rear-ended this guy's car on 287. Nothing happened to his car. Like, you know, my license plate got dented. Nothing happened to his car. I stopped my car. I went up to him. He was an older guy. I asked him, "Are you okay?" And he said, he thought for a bit and he said, "My neck hurts." And I'm like, "Okay, are you able to pull over?" And he said, "Yeah." So he pulled over. I called the police. I called the ambulance. I did all that. They all came to see him. He refused to go with the ambulance, and then he drove away himself. Sure enough, the statute of limitations is 2 years. Close to the end of 2 years, I get hustled with the big, notice letter.
You were served.
lawsuit. Yeah, I got served. Yeah, and and then my insurance company said you have only $15,000 of insurance. If it's going to trial because this guy didn't want to settle. Is going to trial, and if the jury awards him more than 15, you are personally responsible. It scared the S out of me, and just because I'm being recorded. But I went to trial 2 days of my life. I told them what happened. They looked at the pictures, all that kind of stuff, and they gave him 0.
All right, so
Yeah.
you do not want to be V, all right? So I've had 5 clients sued above their threshold. V is not a client, but she could be my 6th example. I used to have 500 and $1 million, not because I'm worth such high amount, but these things, V, how long did it take to get resolved? Because it usually takes several years before it goes to trial.
No, this was a matter of months, fortunately. From the date of the accident, yes, it was years. But from the date I got served to the resolution, to the trial, it was months. And,
all right, but the point is it can take years to resolve. So, and not only did I have that, but after, I used to have $1 million umbrella policy, but then I got $5 million because if you get that 1-page letter from your insurance company that we sue you for X, but you're being sued for X plus Y, you will have many, many, many sleepless nights. So, everyone in this room, if I could do you a big favor, Brian, check your liability coverage, and if you don't, get an umbrella. It's cheap. And what's your deductible? I have no clue. Nick?
Mine is 1,000.
oh my God, people
Mine's
don't have the deductible.
Mine's
1,000.
Guys, I have 2,000 because I can handle 2,000. Everyone in this room,
Mine is 1,000.
you can handle $2,000. But what you can't handle, or at least I can't handle, is if you get a suit above your threshold.
Yeah, you save a lot more money over the long run having a higher deductible than you do on
Right.
anything else.
Yeah.
Like, raise your deductible and get more coverage. Because you
Yeah.
could handle that part.
I think like $1 million of umbrella insurance, like $600 or something like
It's
that.
less. I have $5 million for $600.
Oh, maybe that's the number, but I know
Because
something for 600.
once they're covering you for $500,000,
Anything beyond that's just extreme calories.
Right. Right, so everyone get the message, Andrew, you're well covered?
Actually, I don't have a car. I live in the city, so I have a car all the time now.
Omri was gonna say something.
No.
You're covered?
Yeah, I am covered, yeah.
I sound like Flo, right?
Right.
All right. Suppose there's an unpublished second opinion that is directly adverse. I can't believe this is,
Pizza.
I told them 7.
let me just check. Hello? Yes. Yeah, you're a bit early, but that we'll survive. So I'm gonna come down. It's behind the building. It's where the PNC is underneath. There's a parking lot. All right, drive down, and I'll come to the back, and you'll just go where the underhang, where it hangs over. Okay, take it. Guys, why don't we just hang and we'll give me 15, 20 more minutes, and then just let me get this guy. We'll put the pizza in the back. We'll talk for another 15, 20 minutes, and then we'll take a break. Is that okay? All right, so just give me 2 minutes to run downstairs.
Like, she started a new job recently. From being unemployed to starting a new job. By the way,
I was working. One year I was not working. When I started the course, I was working.
Okay.
Then I resigned because I don't.
Okay,
So-
that happens.
That happens.
Yes.
Then I was struggling to get into somewhere. Now I'm doing internship. New York.
No, but what company you were?
Anderson Times.
Oh, I know the
Zemski's.
professor.
Zemski's were-
Is
yeah.
there
Yes.
too, yeah. I met him.
Yes,
Oh,
he
he
was
was
very
there?
good.
Yeah.
I saw somebody was behind me.
Oh, you remember? Oh yeah, look, like I know a big guy here.
I was like looking for him.
I love this class.
Yeah, I love this class.
I love
Yeah.
this class. too.
Zemski is awesome.
So sweet.
And you actually learn, like I used to dig in those cases.
I love the
Oh, yeah, I like
storytelling
the
style.
cases.
Yeah,
Yeah, I like.
I mean,
I don't like
yeah.
the other.
He would give the history behind it, and he would get into, like, he would tell it like it's a story.
No,
and
that the case you read, it's like some
Yeah.
story. You are
Yeah.
reading. Oh, okay, I can get it.
And his exams weren't that bad. They were a little out there when it came to what you were reading because you're like, okay, but it was actually easy to understand.
Yeah, I mean, I think his exams were like pretty much black and white.
Yeah.
It's like you knew it had to go only one way.
Yes,
Yeah.
exactly, or one thing or the other, but you knew where the mistakes were
Yeah.
and what you had to do.
Yeah.
What do you think about the new professor?
I think he's good. I think he's good. Oh, you're being recorded.
I'm saying good things.
Okay, good. Todd Simmons.
He looks very young.
Yeah, he's cute.
Okay.
Tax practice and procedures. Yeah, last one. Oh, the Tuesday nights, yeah.
All right, so give me a few more minutes, guys, and then we'll take a break. All right. So here we have a Second Circuit opinion that's directly adverse to the IRS. Has not been mentioned by any party. Must IRS counsel disclose the opinion to the court? You guys may recall, I'm just going to remind people, in the Ciaranini case, Ciaranini dealt with the piano, where there's cash found in the piano, if you recall that case. And if you recall, the court said both parties missed citing to Regulation 61-14, which dealt with treasure trove, and scolded the government because Regulation 61-14 specifically says treasure trove constitutes taxable income. People miss things, right? People miss things, right? are you obligated to disclose even if it's against your interest? And the answer here, certainly the IRS. You know, what is the mission of the IRS? Tax compliance, right? It's not, its mission is not to, you know, raise revenue at any cost. So, having said that, in this context then, the IRS certainly should make disclosure, right? Everyone agree?
That's B, we're doing B, right?
Yeah. Should make disclosure. Question 4-6. Does the disclosure obligation of Model Rule 3.3 apply when a tax return is filed? Okay. You know, 3.3 is on the back side, okay, of what I distributed. Okay, everyone see 3.3? A2, candor towards the tribunal. A lawyer shall not knowingly fail to disclose to the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by opposing counsel. Does it apply in the case of a tax return?
No.
B, you say no, why not?
Loving
But,
the case.
hold on, is this our pizza guy or is, I apologize, I didn't turn off my phone, but, I don't know. It's not gonna be the pizza guy, or if it is, sorry. What do you say? Why, just tell me, why did we do cite to Loving? Loving dealt with the issue of
230.
Circular 230 in this context.
I don't know, I mean, the attorney is in the role of a tax preparer. If, so, doesn't that, I mean, I don't know.
Anyone say, does it apply, does this rule, Model Rule 3.3 apply in this context? What do you say? Why or why not? Well, keep in mind, what's the predicate to its application? Failed to disclose to the tribunal. You see the word tribunal, guys?
Court.
Is filing a tax return a tribunal? All right. So chances are you don't have to, on a tax return, you don't have to come forward and list all the reasons why the return might be questioned, right, guys? When a lawyer represents a client taxpayer on audit, so if a field auditor comes knocking on your client's door, you have to make disclosure.
Is he tribunal legal authority?
Well, does the IRS constitute a tribunal?
No.
I don't know.
Yeah.
No, okay.
No, you can't.
A judge, if you were in court, may, yes.
Right. I mean, you can't lie to the IRS, but you don't have to, you know.
You're not
Come-
required to.
Right, tell them all the weaknesses in
Yes.
your client's case. How about when a lawyer represents a taxpayer before the IRS Office of Appeals? Okay, is that a tribunal?
Yes,
Why do you say so?
because it's a form of court.
Is it, the office itself is just the appeals office, it's, I think it falls short of being a real tribunal, Kevin.
Right. Okay.
I mean, I've dealt with some people at the appeals office, it's just an office, I mean, it's not just higher rank than the field office, I don't know, I don't consider it a tribunal.
Okay.
I always go with that.
Sorry, I'm just sharing my, does it make sense to apply different rules at earlier stages of the process of resolving a tax dispute than a rule applied at a larger stage? In other words, you can see that at the earlier stages, you don't have to make disclosure. At the later stages, you do, and our authors are asking rhetorically, does it make sense for different rules to apply at different stages? There is a logistical issue about, does it make sense in the context of making disclosures so early on a tax return, right, guys? May not make any sense. So again, the authors are raising this rhetorically. I don't think there's a good answer to this, so just something to keep in mind. All right, let's take one more thing. Remember, page 162, the heading is exception where disclosure is required. In contrast, C is entitled exception where disclosure is permitted. Okay? But not required. Okay? Permitted but not required. So notice, just so you know, can't make this stuff up. I have the word required highlighted in yellow on one page, on page 163. I have the word permitted. Sometimes these words, they really have true meaning. It's really important to make distinctions. And they spell out in 1.6b, permits in the first paragraph on page 163 under letter C, third line down. The first permits a lawyer to reveal information relating to the representation of the client to the extent the lawyer reasonably believes necessary to prevent the client from committing a crime or fraud that is reasonably certain to result in substantial injury to the financial interest or property of another. Right? And you guys can read this for yourself. And again, it becomes a weighing process. Is the harm or is the resulting harm going to be substantial? And the authors point out, if you look at footnote 2 on page 164, that the rules vary from state to state. And it cites the New Jersey rule, which mandates disclosure, compared to the New York rule, which does not. So, and if this comes up, this is a reinforcement of what I've been saying, is that no one, including myself, is an expert in these very intricate rules. So if this comes up, it may be, how many of us pay $1,000 or $2,000 for car insurance and we sleep at night, or we hope we do. If you get a really tough ethics issue in your office, it may behoove you to retain legal counsel to get that letter, because your professional license, you have to spend Wednesday nights and Saturday mornings and lots of other sacrifices you made. You want to make sure that stays in place, right? All right, so let's look at problem 4-7 and then we'll take a break. Danny, a tax lawyer, is preparing 2015 state and local tax returns for his client, Barbara. He tells her that the $800,000 gain she realized on the sale of her vacation house in Costa Rica must be reported on her tax return. She frowns. Ask him, how likely is it the IRS to find out about the sale, right? It's offshore. Money's in Costa Rica. Danny says he doesn't know. Barbara says, leave it off. Danny says he can't do that. So Barbara says she'll do the return herself. Danny withdraws from preparing the return. May Danny disclosed to the IRS and state revenue authorities that Barbara plans to file income tax returns that do not include gains from the sale of the vacation house. So, in this case, Nick, what do you say?
I would say yes to report.
Yes
to disclose.
Well, we know she should disclose, but could he go to the tax authorities and say, that she's not.
Yeah, because she didn't do it yet.
What?
Turn it in the file.
Brian, do you agree or disagree?
I agree.
Well, me, you, and
I disagree.
Yeah, he can.
Yeah.
What I would do is withdraw from, well, tell her, put it in writing that I notified her and then
He should.
drop her from being my client. That's what I would do.
alright, so you're not gonna disclose it, but Viva, you're gonna say,
Here in rule 1.6B3, by contrast, that if the lawyer knows that my client will commit a crime, so he will affected by that, right?
so what do you say, disclose or not disclose?
Disclose.
I don't think.
When you say, go to the police.
It's
No.
not
I don't think
ethical,
that's a
you're
crime.
What?
You're telling an ethical hotline, you have to call and ask.
Well, I'm saying, what is,
But is that considered a crime though? I don't think it's considered a crime.
Yeah.
well,
It's not a man.
tax,
Evasion.
failure to report is a fraud, so it is a crime.
But you're bound by confidentiality to the client.
But you know that he's doing
With the
crimes.
exception
They're
of
not
fraud,
true, right?
but
I
Well-
mean, so it's under this subtitle, permitted but not required, so obviously it looks like he can, but he shouldn't really.
I'm gonna
So,
keep an
I mean,
appliance
legally
here.
it looks like this person can, but
I'm gonna
shouldn't.
make many friends in the business community reporting your own
Damn
clients.
it, your
Yeah.
reputation.
Don't just make Danny a shitty person.
Yes.
Be careful, we're on tape.
But shouldn't he prevent the fraud?
So obviously you're torn, everyone's, yeah, I mean, you're torn, but
Isn't that one of the exceptions? Why I just cite rule 1.6B2 to prevent the client from committing fraud. But,
so, at the end of the day, I think, look, one thing's for sure, look how this is framed. May Danny disclose the IRS and state authorities? Barbara says she'll do the return herself. Do we know for sure she's gonna commit a crime?
We don't know.
Mm.
No.
We don't know.
I think here again, they're gonna prioritize client confidentiality. You're really, because if you go to the police, okay, and she says, look, I filed a return and I didn't disclose, I reported it, and she's mad because, who wants the police knocking on your door, right? So she may go to the ethics committee and say, hey, here's a client, here's a practitioner who's making disclosures.
That's only because it's based on the fact that it says that she's just gonna do it herself, right?
Right.
So you're just going with that, all right, you do it yourself, that's,
Yeah, you don't know for sure she's gonna commit a
so
crime,
you just accept that as her answer.
right? I mean, again, when in doubt, you really
Don't disclose.
don't disclose except, again, she definitely has an expectation of privacy here, right? So we know that it's not like Myra in the diner, all right? Different thing. Same facts as A, except that Danny told Barbara in response to her question that the IRS would probably never find out about the sale if she left the money in Costa Rica. Well,
We missed.
oh, I missed something?
If not, then, and the same question.
Oh, I apologize. If not, if Barbara tells him a month later she filed the return without reporting the gain, may report this to the IRS and state authorities. And your answer is?
It's the same.
It's the same, right? Because now there's no, the crime has been committed if there is a crime. Her disclosure is not gonna prevent a crime. So, client confidentiality. I mean, why do you want why as a general policy matter does this make sense? Because the idea is by emphasizing confidentiality, the hope is someone like Danny can coax the client to comply and say, listen, if you don't do A, B, and C, you may be in prison soon, and scare the heck out of her. But if she knows that you're gonna go right to the authorities, she's not gonna say a word. Is there a perfect answer here? There's no perfect answer, but the better answer, at least society thinks so, is to maintain confidentiality.
But then that applies to Jan too, right? If Jan,
Jan is the,
Jan is the
tax
lawyer
lawyer.
at the diner.
right?
No, but there was a plumber there, a third person.
Yeah.
Yeah, but,
Earl was there.
but this person would have shut up also if
No,
Jan,
but
if
that
she
person-
would have known that Jan would have gone to the authorities.
that person isn't required to shut up.
Well,
I mean-
you know, it's a different expectation.
Yeah.
If Jan has a big mouth, you have or Myra has a big mouth, you have yourself to blame for it. All right, finally, is he required to do so under the ethics rules? And the answer is no. And then question B, how do we, the answer change if Danny told Barbara that she would never probably be found out? In this context, what does Danny look like he's doing?
He's enabling.
He looks like an embedder. He's like coaching. Like, this is good. This is better than if you sold property in the U.S. So all of a sudden, you may be considered assisting in a crime, right? So this is problematic on many different levels.
You could lose your license.
Right? And as I've already mentioned, in this day and age, the technology is incredible. How many of these guys see advertised, like these little cameras that you could watch your nanny and all sorts of things that, so who knows when you're having this little conference with your client, who's recording whom, and so be careful.
If we sell the property, then you will, now they issued a form, right, for you? It's called, sorry.
Well, this property is being sold in Costa Rica, so you're not gonna be issued any information return,
Oh, okay.
all right?
In US we got it, right? If we sold our house or something, then.
Yeah, no, then you'll get definitely get a 1099.
Okay.
Question C. Same as A.
So what was B again?
B is a problem to the practitioner because you have abetting a crime. I think it's code section 7201. Same facts as in A, except that Barbara never told Danny about the sale of the vacation house. He prepared the returns and signed them as preparer. Barbara filed her returns with the IRS in 2016, well before the deadline. Before the deadline lapses, right? Before April 15th at a cocktail reception, local museum, Barbara mentioned that she made a quote-unquote killing on selling my vacation house in Costa Rica last summer. Danny says, what? Barbara says, oh, Danny, don't worry about it. The IRS will never know. May Danny disclose the contents of this conversation? Must he disclose this conversation? What else might he be thinking about doing? So,
I would say yes.
Now say yes.
now, Viva, what do you say?
Now we are disclosed.
Why do you say that, and how does this change?
Now she knows after the filing the document that the client did not say the truth about this thing. So maybe just what? 1.6B3. I think it was contrast now.
The fact that he signed the tax return
Tax return.
puts him in jeopardy as well.
But his information is based on, client provide.
Yeah, the client is
So
using.
if he don't tell you anything, so even though you sign, you submit,
Right.
it's not your fault because you cannot.
Well, it's not your fault, but now,
You have to say something.
look at what 1.6B2. 1.6B2. To prevent the client from committing a crime or fraud that is reasonably certain to result in substantial injury to the financial interest or property of another, and in furtherance of which the client is used, notice the past tense, or is using the lawyer's services. So here, the lawyer's services are being used to perpetuate a crime, right? Because he prepared a return that's fraudulent in nature. So, where does this leave you? What would you do?
Amend and return.
I would report.
And by the way,
Maybe amend and return.
say again?
I would report.
I mean, you could amend the return,
Yeah,
but it
amend
looks
return.
like Barbara ain't filing your amended return, right? And you can't file that unilaterally, right? So, what would you do in this very sticky situation?
I would report her to, save my skin.
What do you mean, say it again?
I would disclose it
To
to
who?
the authorities, to the IRS.
Well, Here's a cop. Obviously, my old mantra, call the ethics hotline, maybe, secure a legal opinion from someone, all those true. But for exam purposes, because that kind of becomes a hollow answer, for the exam, just don't put 1-800 call. That won't get you any brownie points, okay? But the right answer probably here is to coax the client, file an amended return. If she declines to withdraw from representation, I know, Kevin, you're saying make disclosure. That always gets me unnerved, because the crime has been committed and it's a weighing process. So I think if you take these steps of saying, look, I can't represent you anymore, and you create a memo to the file and do things like that, I don't think the AICPA, the CPA licensing board, the American Bar Association, the licensing board, that you could really get in trouble.
Okay.
Because there's such a premium put on client confidentiality, fee notwithstanding, again, where there's an true, meaningful expectation of privacy, which there would be here, right? But not in a diner. All right. You've been patient with the aroma of that pizza in the background. So let's do this, guys. We'll take a 15-minute break now, and then we'll convene. Thank you, Kevin, again for helping us here with these. Right? There's no plates apparently. They left those out, but there are paper towels obviously in the bathroom.
Oh, here, I have another water bottle.
So I think my husband paid some half money.
Are you gonna pause that?
After 5 years,
Yes, thank you.
Yeah, like, what, if you put hard, back